This is continuing coverage. The Black Swan murder trial of Ashley Benefield from the Hidden Killers podcast and True Crime Today. Now back to the courtroom.
All right, do you see what the state's saying?
Yes, I do. This is a rather unique factual situation. I'm not sure at this point I have an answer for it.
All right, I'll outline it, and let me just say that having served on many rules committees in the past and currently serving on a rule committee, it is yeoman's work what they do. And I can only imagine how many hours went into the criminal jury instruction committee putting 3.6F and 3.6G together. And I know sometimes we will fuss, or I will fuss, at the complicated nature of these jury instructions, but they really are good, and I appreciate the work of the committee. So to put it simply, on the standard jury instruction, from the part of give if defendant is relying on 776012 sub 2 or 776031 sub 2, but is not relying on 776013. Because 776031, as we know, gives even greater protections or establishes and explains the Castle Doctrine, from which Stand Your Ground expanded that Castle Doctrine out into other places. But I think what the jury instructions are saying in interpreting the case law is that if the defendant is relying in part on that home protection, 776013 subsection 1, a person who is in a dwelling or residence in which the person has a right to be, has no duty to retreat, and has the right to stand her ground and use or threaten to use, and then A, non-deadly, and B, deadly. And the reason that distinction is made in these jury instructions is because if you're not, you automatically get those protections in the home, right? But 776012 is more of the general use or threatened use of force in defense of a person. And in that situation, the additional information that because it's not in the residence, the jury has to be instructed on the duty to retreat or the non-duty to retreat and a right to stand your ground if the person using or threatening to use deadly force is not engaged in criminal activity and is in a place where he or she has a right to be. Obviously, because 776013 is in the home, which Ms. Benefield was, would lend itself to the argument being made by the state that we would not have the first part of the standard, but we would skip down to give if defendant is relying on 776013 subsection 1, self-defense in the home, because it has all the same things, except now you're in your home, so the jury does not have to consider that you, whether or not you're engaged in criminal activity or whether or not you're in a place where you have a right to be, because you are.
Judge, what is 0312?
0132?
No, 7760312. It says give it.
That's defensive property. Yeah.
I remember putting the instructions together, but I didn't remember what the substance was.
So I think, and of course, it's imminent death or great bodily harm to herself or the imminent commission of the forcible felonies. And we still have to, once we determine which forcible felonies we're going to give. So that's just me putting that on the record for future reference, posterity's sake. All right, the next one is.
So are we taking that first part out?
Well, I'm just putting what my interpretation is of these jury instructions and why I think ultimately we're going to give the second one, 776013 sub 1, as opposed to 776012 2. I don't think we've had any arguments about necessarily 782.02. Essentially, 782.02 is essentially a restatement of what we would cover under 776.013 sub 1. I think it's kind of duplicative, and I'm sure each side will have their own arguments.
Judge, I think just for timing, I think we're going to go, so I don't know that we're going to have a lot of time. You know what
I understand.
Okay.
I was going to ask the court, you already announced if you close in the afternoon, so we'd be able to clean this up.
I'll just say that I was kind of leaning that way, that whatever rebuttal you want to do, cut them loose, and then whatever, we still got a end of the road JOA, if you want to make one.
Yeah.
And then I figure that's it. Now we know what evidence is in. We can put the final touches on everything. You'll have had this evening and tomorrow morning to look at these issues and get them finalized, and you guys make the copies for us. I usually ask the state to make all the copies with and without verdict form and so forth. And then come back in the afternoon, give them an early lunch. But if we send them away early, we can have them back at 1 o'clock, 12:30, whatever we want to give you guys time to do your closings.
I don't need.
How much time do you think you're going to want to ask for closing?
First and second?
Yes, total. Mr. Taylor?
I'll take that, but I doubt that.
Yeah, I don't.
So I'm glad you asked about timing. Yeah, I think you're right. That's probably what it's looking like. We'll be here first thing in the morning, any rebuttal, then rest, and then I'll let them go and tell them to be back, whatever makes sense, 12:30, 1 o'clock. Then we'll come back, we'll stay, get all the jury instructions done. When they come back, we'll go.
Want to find out what rebuttal is, so make an argument, we have it, or...
Yes, absolutely. Yeah, but let's cover that in the morning.
Okay.
All right, so we were on the 782.02. I'll let you guys argue, but I think that, that might be duplicative of what the instruction that's already going to be given from 776.013 sub 1. And then the next paragraph, in deciding, that certainly needs to be in there. Oh, that's where we left off. Were there any of those forcible felonies that you're prepared to agree with right now? That way it'll limit what I have to hear argument on.
And I just wanted to make sure I got them all. They were burglary, aggravated assault, aggravated battery,
Felony bat
felon bat.
and false imprisonment.
I thought I heard false.
That's in my package.
It might be, but I just find it. And just to be honest with you, I've never had more than read, so I don't quite know how to respond.
Yeah.
Typically, the defense will focus in on what they say the crime is.
Well, you guys both know, it's only the elements, right? The crime of burglary is, the crime of felony battery, just the elements.
Well, we would need, for this case, obstruction then at a quick property.
Understood.
And Judge, I think remaining property on the other crime.
I don't know if we can agree, because I don't think that I can say, I don't think that there's evidence that has come in, felony battery, aggravated assault. And then false imprisonment, I'd have to go back and read. That one may have evidence. Of the burglary, I'm not sure, because I don't know what the evidence came in that committed crime therein. But I didn't do it. But I could say that I would almost guarantee I got that.
All right, so be prepared for that. I'm not saying you need to commit to it now. I want you both to be able to go back to your offices this evening. This is why I do this big overview. That way you guys can go back. You've already heard a little bit of each other's thoughts. Nobody's locked in, but then you can come back tomorrow loaded for bear. All right. Presumption of fear.
Presumption.
Yeah, the 776.013 sub 2.
I don't think this comes in because it's forcible as well. I don't think there's any evidence of unlawful force.
Yeah, I think I might.
I think so. So that would be
I
out.
think thereby the next.
Yeah, which is the presumption does not apply if. So it's both ways. The presumption applies if and does not apply if. I think that can all be out. And then that last portion too, because it's all talking about by force.
And just under the world, that's the part that 7.014.
Yes, ma'am. And so the next part about 776.041, there's certainly, it's only the one charge. There's no other forcible felonies.
And I think we can take vehicle out right above that. But yes, I don't think of this.
Right, there's been, and I don't expect any evidence that the defendant was attempting to committing or escaping after the commission of some other forcible felony. And so I think that's all out. State the next one regarding aggressor, and whenever the defendant, there's some evidence where the defendant was the main or initial aggressor, and then the force comes back when the defendant would be justified in using force when they were the aggressor. I don't either.
I'd already crossed.
Okay, is that all right? I don't recall any evidence that Ms. Benefield was the initial or main aggressor.
It's down at the bottom of the page as aggressor and then.
Yes, okay.
All right, so that will be out. The next part is absolutely in.
Yes, I
'cause
think
that's
the next two parts are.
the thrust of the defense. So prior threats is in. However, the reputation, I don't think there was any testimony regarding reputation of the victim.
And then the ability.
Sorry?
The last one.
Yeah, physical ability
Yes,
is in.
absolutely.
And I will fix, I probably know them tomorrow once they're all.
If you would, that would be great. I'd appreciate that. All right, so see, this is why I do this kind of general overview, so at least we can figure out where the touch points are for disagreement. All right, that's 3.6F. We're not giving 3.6G, right?
Sorry.
Use of non-deadly force. Everybody agrees?
Yes, yes.
Okay.
Sorry, I got this.
No, I just want to make sure, because there's some cases out there that talk about both of them. You give one, you give the other.
I think it says now in the new standard, it said at the bottom, unless evidence establishes force or threat which was deadly and non-deadly as a matter of law, and then it goes on, it says discharge of a firearm, whether actual or not, be deadly.
I'm still going to belt and suspenders it and make sure everybody's agreeing we're not giving 3.6G.
I understand.
All right, so now this should be pretty quick the rest of the way. 3.7, plea of not guilty, reasonable doubt.
Yep.
All right. 3.9, weighing the evidence. Now, on this one, Ms. Benefield, of course, Mr. Taylor's has the copy right there. The 10 issues regarding credibility and factors for the jury to consider, 1 through 5 are given in virtually every case I've ever been involved in. We do 1 through 5. 6 through 10, however, really depend on the facts of the case and whether there's factual support for giving it. So 6, any evidence of 6?
No, state doesn't.
No.
All right, 6 is out. 7, pressure or threat, state?
I don't think-
Defense. Any argument you want to make about pressure or threat?
I don't believe so, Judge.
All right, 7 is out. 8, certainly 8 stays in because there's been some impeachment. So 8 becomes 6. 9, there's been no conviction,
9 and
impeachment.
10 are out.
Right, don't expect any of that. And 10, we don't expect any reputation for truthfulness or honesty. All right, so it looks like 8 becomes 6, and that one will be good.
Then I just need to unhighlight, and I always highlight
Right.
that number until we're done.
So, yeah, page 2 of that is going to be unhighlighted, but needs to be given. The defendant has become a witness. And so, oh, you already took out 3.9A?
I did, 'cause
Okay.
we fixed them last night.
All right,
We could.
Mr. Taylor, because this is our first trial together, at 3.9, I stop. So for the initial instructions, I go all the way through 3.9, then I stop, and then I will explain the verdict form to the jury and go over it and explain how it works. That way you don't have to use your valuable closing time explaining how the jury verdict form works. You can just get right into it.
Okay.
When we come back, I'll touch on 3.10, and that looks fine. 3.11 cautionary, that looks fine. 3.12. All right, so 3.12, when then we come back and I give the final instructions, I of course read 3.12, but down at the bottom where it says it is as follows, I just tell the jury I previously explained the jury form. All right, 3.13, submitting the case to the jury. Did you already take out the thing about questions?
Yeah, that's actually on, I think that's on rules for deliberation, which I already took out. But yes, I took it out.
Yeah, no, it's on 3.13.
Oh, okay, I'm sorry.
There's, in 3.13, it's not in the state's version because they already took it out. There's the one paragraph in the standard that talks about questions that were asked during the trial by the jury but weren't answered. And I removed that because I don't allow jury questions. And then at the bottom, during the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help you in your deliberation. These exhibits will be sent into the jury room with you when you begin to deliberate. However, and it's up to you, we can craft this in here, but I usually ad lib at that point. For example, if it's a child pornography case, you got to come out and view it. If it's a CPT tape, you have to request to view it. In this situation, I would say we're going to send the firearm back with you. Is there live
There's
ammunition?
no live, we did not bring it.
Oh, okay. I thought there was.
Correct me if I'm wrong, clerk, but I believe it's all casing and
So the testimony was that live rounds were found. There was a live round in the chamber and live rounds in the magazine, but those live rounds have not been introduced into evidence.
correct, they were packaged separately by crime scene and we did not bring for that reason.
All right, so with that said, everything goes back, unless you guys say something different.
No, I just wanted to wait because I know because it was a firearm, but I think it should not get all the paragraph.
So usually, if there's a firearm and magazines and live ammo, it's one or the other. Either you can have the firearm and the magazine, or you can have the live ammo, but I don't have that problem here. And then in closing, let me remind you, now the verdict form, aren't we gonna need some special interrogatories?
Oh, yes, sorry.
Let's say mine is just,
It is. And I was looking at it thinking, wow, this is really short. Yes, sir, I'll fix it tonight and then we'll have to look at it tomorrow, but.
the one that we end up usually using, as you would imagine, the defendant is guilty of murder in the second degree as charged. And then underneath that are the special interrogatories for the 1020 life. Then you'll have B, the defendant is guilty of manslaughter, a less included offense, and there's the one interrogatory regarding actual possession of a firearm. And then C, the defendant is not guilty. So that's what it should look like. But obviously you've tried cases all over, so if that's the standard we use here in the 12th here in Manatee. If there's some other format that you used before you think is better, certainly willing to listen.
I'm fine with it.
All right, thank you very much for giving me that extra half hour and going over the jury instructions so we understand who's where. And if there's nothing else, Richardson, do you want to do that tonight or do you want to do that in the morning? Okay.
Judge, and I'm going to show them an exhibit I intend to use tomorrow. They may have, this did not become relevant. Rebuttal. I mean, it's for rebuttal. It did become relevant this time.
Okay, so have the photographs, which
Yes, sir.
as well. Apparently, the state is go all full base strike course.
Judge, and I can maybe simplify. I intend to ask her a question about this picture that I'm holding up. I intend to ask her a question about the pictures that were produced by Vince of the gym pictures, just to ask her if she's familiar with those and when they were taken. I also intend to ask her if her father was right or left. That's all I have. So I don't know that sitting in would have been there.
All right, can I see the picture you're
Yes.
talking about? Is there an issue, what's that one marked, what number? State?
105. 105.
Was this one disclosed?
Yeah,
You got 105 or no?
yeah, that's the photograph.
Right,
Just now, because it was not relevant to her rebuttal.
that's what I'm asking.
That was not in discussion.
Okay, there we go. So we're going to include states 103, which we referred to as the modeling photo, 104 as the mugshot, and 105, I'm just going to call that one the boat picture, or boat photo, because they're on a boat. All right, yes, sir.
Want to take ours?
How about the Richardson violation?
Yes, so they were never provided at all in discovery. Not only were they not provided, but let's be clear, because if I've learned nothing else, I've learned this. They weren't provided in a dump at any time, so we were completely unaware of those photographs.
And can I just ask, is that argument for all three of the photographs?
Yes, we, to our knowledge, were never provided with that photograph either.
No, the reason I'm asking is because the mugshot photo was entered in the stand your ground, so I don't think that was.
Well, hold on, let me keep some semblance of order, even though of the late hour. So, right?
I thought
I-
the mugshot's in already.
That's one of the
Yeah,
mugshot.
so here's the three photos we're talking about for this Richardson hearing. States 103 is what we've been referring to as the modeling photo. Go ahead and pull them out, I'm so sorry, Madam Clerk. She asked if we wanted them, and I said no, and now it's probably better we do. That's 103. 104, been referring to that as mugshot, and 105, we're now referring to as the boat picture. And the mugshot, my notes are 103 and 104 were not admitted.
Correct, and that was just an oversight. They were published and we spoke about them, I just didn't say the words.
Correct. All right, so I have them up here if you want to review them.
And
I have them here if you want to review them.
would like to say the mugshot was disclosed in discovery. I can find the discovery page, the bait stance page if you need me to, but it was disclosed in discovery.
You can take those with you if you want.
Yeah, there was a companion photograph with this that they sought to introduce that we never got either.
No, it was that one.
Was this?
It was that one.
Yeah, just
Oh,
those two.
okay, I could have sworn there were two. Okay, so you want me to address the wedding photograph, the modeling photograph?
Yeah, all three of
All
them.
three,
Yes, sir. Go through the Richardson factors with me on all three.
So, we believe it to be, I have no evidence to present to the court that it was intentional. We believe it to be inadvertent. However, the prejudice is substantial. And given the late hour of the introduction, we've never been advised, so we've had no opportunity to meet it. And the trial is over.
All right, State?
Judge, speaking about them individually, and I apologize, I don't know which picture the mugshot is, but that was disclosed in discovery, so there
104.
is no violation. What we call modeling photo, I believe that's actually from the ballet pictures. That picture did not become relevant until the defense's case, and the defendant testified, and also Dr. Russell testified about seeing edema and swelling, and it became very important to show before this incident and after this incident what she looked like. And I don't know how that can be of any prejudice because it's a picture of the defendant. It's not like she didn't know it existed. And I don't know how the defense would have prepared differently. So I don't think it's a violation, first of all, because it didn't become relevant, and we introduced it at the time when it became relevant. And then as as to the boat picture, I have the same argument that that did not become relevant until the defense's case. So therefore, we produced it as soon as it became relevant or very close thereafter. So it was no violation to begin with.
All right, tell me about, what is the relevance of the State's 105?
The relevance is that the defense put in pictures of the victim at the gym to show that he was all muscle bound and, to try and show. Those pictures were taken in 2018.
Which pictures?
The muscle bound pictures that the defense put in.
Okay.
That picture was taken a month before he died. He did not look like those pictures that the defense entered in 2018.
How do you know he's got a shirt on? I mean, if you look at his arm, the vein is bulging on his
And that goes
bicep.
to the weight, not the admissibility, Judge.
When did you become aware of State's 105?
Last night.
All right. Final thoughts to the objecting party.
Put in about Mr. Benefield, how he was built, were in May of 2020.
I don't recall that evidence coming in. The date of them?
I'm just informing the court. The representation was that they were taken in 2018. We're telling the court they were taken in May of 2000.
All right. And just so you all know, and what I'm saying to that is, as someone who hasn't been involved in this case as long as you guys have been and don't know all the details of it, I don't recall that testimony when the photographs were put in. I don't think the date of them was established.
I'm just correcting representation that they were May 2008 or they made that.
All right, thank you both very much. So in a Richardson hearing, obviously we talked about it before, the issue is whether it's willful or inadvertent, trivial or substantial, and what prejudice is being suffered by the non-offending party, that is the one that's opposing the introduction or didn't have the information or exhibit. I'm going to start with 104. Actually, all three of these have a different analysis, unfortunately. And I'll just mean that because that means I have to go through it 3 different times as opposed to giving you just one simple analysis for all 3.
Judge, I'm sorry.
Yes.
I just want to make sure. We haven't yet discussed the Richardson analysis or the model photo.
Yes.
Oh, then I want to add something.
Oh, please, yes.
Yeah, prejudice. So the court may call, I specifically pointed out drooping eyelid and the space between the brow and the eyelid. The prejudice to us, so stand, they're going now. It's this picture taken at time with makeup and everything else. They're going to argue that she looked like that here. Therefore, can't believe what they said about the photo that was taken by the sheriff and staged on that day. That's going to be substantial. And one other thing, Your Honor, about the photo with daughter-in-law. There's a simple fact about all order him with YJ. Now this is a second bite apple. And if they want the photograph really just show that by some crystal ball, they know he's not built like that on his shirt, then they should splice the photograph, remove the photograph just to show it off.
All right, thank you both very much. So 104 is an easy call. 104 is the mugshot, and that has been disclosed. It was used at the Stand Your Ground hearing, and in one of the more recent pretrial hearings, this in particular was one of the issues we talked about, and I was on my way to ruling that the state could not use it in its case in chief, but could use it in rebuttal, and that's where then one of the two of you jumped up and said that was your intent anyway, was to use it during rebuttal. So I don't find that there was a Richardson violation. That's been disclosed. It was discussed multiple times as this case is going on, so there is no prejudice there. As for 103 being the modeling photo, when did you get this picture?
I think it was the night, either the night before her, at lunch. It was at lunch during her testimony.
I found it on the internet while we were eating lunch and then turned it in.
And tell me your prejudice for this again.
I had specifically pointed out when we put Ms. Benefield on the stand where the slap was beside the left side of her face, and asked her about whether her eyelid was, it reflected a droopy eyelid and swelling in the space from the eyelid to the eyebrow. And the state is now going to use that photograph to argue that that wasn't the case at all. There were no swelling, no damage, because here, take a look at the eye in this photograph. It's exactly the same.
And Judge, I think that's,
And then they might just add, can I put this on the record ex parte? I don't want to help the state in their closing argument.
All right. Surprisingly, I find this to be a much closer call. It's difficult to say that it was willfully held by the state because they didn't get it until the lunch. Direct happened in the morning, then we took a lunch break, and then cross happened in the afternoon. Let me ask you this, State, and I hate to do this because I know I'm usually very specific about I want to hear all argument and then I rule. When you procured State 103, you come back over, did you show it to the defense prior to beginning your cross? I'm sorry?
I showed them both of them.
Both of them?
And Judge, I just want to also add, defense saying that they would not have spoken about the swelling on the side of her face, that same argument goes for the mugshot. And they had every reason to know that I was going to try and put the mugshot in after she put it in the evidence. So I don't know that that argument necessarily holds because they were on notice that I was going to make sorry, just maybe not with that picture.
All right, I do want to give you the final shot, though, since you're the objecting party. Anything else?
Well, the mugshot is 6 weeks later, and you can't discern from the mugshot what can discern from this photograph that we are discussing now. Again, the composition also are different makeup.
I think that goes to the weight, not the admissibility. All right, so the state didn't have this until that day. They showed it to the defense prior to beginning their cross-examination. The purpose is not, I characterize it more as a rebuttal piece of evidence based upon the defendant's claim about the slap and so forth, and I understand why the state wants to use this, because they have 104 is coming in, which is the booking photo, but I look back at my notes just to see about 103, and on 103, when it was authenticated by the defendant, it was a modeling photo, and it was taken before she even met Doug, are my notes. So I have to find that there's some sort of prejudice, and that the defense would have changed or been significantly different to meet that prejudice, and I just can't say that I find that, because the issue of the swelling above the left eye has been an issue since the stand your ground, and all 103 does is show the anatomical structure above the left eye at a time before she even met Doug. So I can't find that there's a Richardson violation. So 103, over the defendant's objection, is admitted. The predicate was laid. For 105, this is again, it's difficult to say that it was willful because the state just obtained it yesterday or the day before. When's the first time you disclosed it? Today? Well, I'm sorry, that's not 104. I apologize, Madam Clerk. 104, I found there was no Richardson. It is received. 103 and 104 received. 105, I don't think. First, so I can't find that it was willful. Trivial or substantial, I think it's certainly the relative size and physical abilities between the defendant and the victim is an issue, and the defendant has the photographs, whether they're from 2018 or 2020, the photographs of Mr. Benefield working out, where he is in, to put it mildly, extraordinary shape for a man his age. So I don't think it's unreasonable for the state to want to put in a photo of what he looked like a month before his death. I think it goes to the weight, not the admissibility of the photograph. With the argument between the two parties, defense can argue, yeah, but this shirt doesn't show him ripped. These other ones show him with his shirt off. They can make that argument. The state can argue that he wasn't as ripped and strong as he was in those photographs. But I don't disagree, and I've done this before where editing the photograph for the fact of having his daughter in, and it's going to come out that it was a month before a month before his death. They're both smiling on a boat, having a good time. I think there's some, not the prejudice as preparation prejudice, but no, this would need to be.
I did respond.
Yeah, go ahead.
Judge, I relative of them to his daughter. They know their daughter must take help side by murder or prop daughter out.
All right, I appreciate that. Overruled. Either way. Now, the question for you is, do you want this in?
I crop it, print it out on a.
It's already been done.
Well,
it's already done. Right.
Oh, were you asking if I wanted the other half?
Yeah, do you want the other half?
Oh, I'm sorry. I didn't understand what your question was. I'll take the other half.
Well, I didn't know if you'd want it in the record, because you're saying you want it in. Do you want it in for?
Oh, we can just put it in the record. Thank you.
Can I call that one 105A?
A. Yeah.
That's going to be State's Exhibit 105A. It is not entered. So the only ruling I've made at this point is 105 is admissible as I've cropped it.
Okay.
But we still have the issue of, you want to get it in through Eva.
Yes.
Benefield,
Yes.
and you're objecting her being recalled, so we still got to get that issue.
Yes.
All right.
Object to it being recalled on two bases. One, sympathetic, especially balanced against probative value of this photograph, which is anybody's guess because it's got a shirt on. Two, based on the hearing that we had.
Did you do any additional research on, I made the ruling about the interview, right, that happened in the hallway?
Yeah.
All right. You had started to bring up some other matters, and I don't know if anything ever happened with that, no?
Yeah, I left it alone, I think, because she said she took posts down.
Took them down, all right. All right, be heard on whether Eva Benefield, now, the rule of sequestration was applied.
Yes.
She was not released from her subpoena,
Correct.
but she was allowed back in the courtroom pursuant to Marcy's law
Yes.
as next of kin.
Yes.
All right.
And I think the entire reason for the rule of sequestration is to provide fairness. So witnesses can't hear what the other witnesses are going to say where they testify, where it may taint their testimony. I represented to the court like 4 questions I will have for her, and I don't think that any of those would have changed based on anything that she would have heard in the courtroom anyway. And even that being said, Marcy's law has shown that her right to be in the courtroom is more important than those types of issues anyway. So I'm not really understanding the defense's argument about her coming back in, and there are issues that are relevant to the state's case that the state wants to ask her. So I don't understand the sympathy argument.
All right, final thoughts, sir.
I think the sympathy argument is pretty obvious, and they already put her up there one time, so now we're going to put her back up there a second time. Marcy's law allows her in the courtroom, it doesn't allow her in the witness stand.
All right, thank you both very much. I made the findings the other day regarding what I understood to be about the brief interview that was given in the hallway. I believe there was an admonishment and she was allowed to remain in the courtroom, although I will say she was kind of in and out. I don't find that it's overly sympathetic to recall her as a rebuttal witness to authenticate a photograph. You said something about the gym photos?
Right. She was going to talk about the gym photos.
How so?
When they were taken.
All right, and then right or left-handed?
Yes.
That doesn't sound like anything that would necessarily pull at the heartstrings. I will say this, obviously on that boat photo, it doesn't need to be, was that the last time you went on a boat with your dad and, you missed those times? It needs to be, when was this photo taken? And then you can make your arguments however you want to interpret it during closing, because that could be overly sympathetic to kind of dredge up those sorts of emotions. And then right or left-handed, I don't see anything that's overly sympathetic or, in my head, I'm doing a 403 analysis. So I think the probative value is not substantially outweighed by the danger of unfair prejudice, confusion of the issues, or misleading of the jury, and I don't find it to be needless presentation of cumulative evidence. So you may recall her for those limited purposes.
Judge, if I see the picture where you cut copy, could you see a picture of the digital copy?
All right, if that's everything we can handle tonight, you all are free to go, and we'll get started tomorrow morning. Yes, yeah, 8:45.
More continuing coverage is on the way. The Black Swan murder trial of Ashley Benefield from the Hidden Killers podcast and True Crime Today. Press subscribe now.